Ladies and gentlemen, welcome to the 5th lecture series of the DIFC courts in 2014. Before introducing the Chief Justice to speak, I'd like to tell you that the courts are in good health. For the first time in our history, over the last 12 months, claims exceeded 1 billion dirhams. In fact, they're at 1.4 billion dirhams. And our average claim size trebled year on year and now stands at $11 million in the Court of First Instance. Settlement rates remain at over 90%, and in the Small Claims Tribunal, settlement at over 90% occurs within 4 weeks. So the courts are in good health. I'd like to introduce you to the Chief Justice of the DIFC courts, Michael Han Kuang, a former High Court judge in Singapore, an author with a book of essays on international arbitration, recognized as one of the world's leading arbitrators, former president of the Singapore Law Society, former non-resident ambassador for Singapore in Switzerland, and a former partner, and head of litigation and arbitration in Singapore's largest law firm. The Chief Justice has considerable experience both of arbitration and litigation, and to that extent it's a great pleasure to welcome him to talk about the proposed new practice direction. Chief Justice.
This comes of having to follow Mark, you see, the way the microphone has to come down. As you know, today I'm going to be talking about our new protocol as set out in the practice direction. Before I start, I want to acknowledge the people who made this protocol possible. First, as far as I can tell, the person who originated the concept was Tim Taylor, QC of S.J. Berwin. His comrade in arms in this particular project was Rupert Reed, QC of Wilberforce Chambers in London. They also collaborated with a number of other distinguished international arbitration practitioners, mostly situated in London. And their ideas were then fed into DIFC courts, where our Assistant Registrar, Natasha Bakirci, did a wonderful job of synthesizing all the various ideas into that first draft of the practice direction. And so these are the people whom I've had the privilege and pleasure of collaborating with on the final version of this protocol. And with that, I will now proceed with the lecture proper. Now, in your handout, you should have the original practice direction in draft that was sent out for public consultation a few months ago. We had a very good response from the DIFC bar as to what people thought about the protocol. We've taken very detailed cognizance of these suggestions, and I'll be addressing them in the course of this lecture. You also should have now the revised protocol dated today. That is not the date that it will take effect, because after I have explained to you how the revised protocol works, I think we will still have time for some more feedback, although within a much shorter period, so that we can fulfill our aim of getting this practice direction in force by early next year. So first of all, we have a working title for this protocol, which is called the DIFC Court's Judgment Award Protocol. And the reason for that particular formulation you will find out in the course of the lecture. One of the known limitations of state court judgments is that they are not normally enforceable outside their home jurisdiction in the absence either of some common law or international doctrine of extraterritorial reach or a bilateral or multilateral treaty providing for reciprocal enforcement of judgments. European Union countries have the latter arrangement, as have some other regional groupings. In this part of the world, we have the GCC Convention, which provides for legally enforceable recognition of judgments of all GCC countries within the GCC. To a lesser degree of certainty, the Riyadh Convention also provides for reciprocal enforcement of judgments within the MENA region, but most lawyers would hesitate to say that the Riyadh Convention represents enforceable black-letter law. When lawyers discuss the benefits of arbitration versus litigation, the conventional wisdom is that arbitration awards have universality of enforcement under the New York Convention in over 150 countries, while state judgments do not travel anywhere near as well. Today, I want to discuss an initiative that the DIFC courts have formulated, which could be the model for other countries to adopt so as to make state court judgments as enforceable as arbitration awards. Indeed, our aim is to provide a process whereby court judgments can become the basis of an arbitration award, so that the monetary relief granted by the judgment can become the same relief granted by a subsequent arbitration award and be enforceable as such in all New York Convention countries. I'm of course referring to our recent Draft Practice Direction X, which was released for public consultation some months ago. We have now concluded our review of the feedback received from respondents, which have been both substantial and helpful. I will share with you the feedback we have received from this consultation, but let me first set the scene by explaining the relationship between courts and arbitration in the DIFC. We in the DIFC addressed the issue of courts versus arbitration when the DIFC was first established in 2006. The original concept was that the DIFC courts would have a partnership with the proposed DIFC LCIA Arbitration Center. And for purposes of this lecture, I will just call it the Arbitration Center. We would handle litigation and the Arbitration Center would handle arbitration and mediation. When our courthouse was built, the DIFC courts shared our premises with the Arbitration Center for some years, until our expansion made it necessary for the Arbitration Center to move out and seek alternative premises. However, we have turned full circle, and as from this year, pursuant to Dubai Law Number 7 of 2014, the courts and the Arbitration Center are now legally housed together under an overarching authority known as the Dispute Resolution Authority, which comprises two arms. First, the DIFC courts with myself as the Chief Justice. Second, the DIFC Arbitration Institute, which we are going to call the DAI. And that is the operator of the Arbitration Center, and with myself as the head of this institute. So we have an unusual situation of a Chief Justice who not only heads the courts, but also acts as the nominal head of the Arbitration Center. And I emphasize the word nominal. I'll come back to that a bit later. I should point out that this is not unique, because Singapore had such a situation some time ago when the Singapore International Arbitration Center was housed in the Supreme Court building and was managed under the supervision of the Academy of Law, whose president was the Chief Justice. Under our arbitration law, all arbitrations seated in the DIFC, which I remind you is an independent seat within Dubai, are supervised by the DIFC courts, which therefore act as a curial or supervisory court of the Arbitration Center, as well as other arbitrations seated in the DIFC. To prevent conflicts of interest under the new legal structure I have just described, I have appointed a board of trustees who will effectively oversee the business and caseload of the Arbitration Center and who will not report to me. The Arbitration Center will therefore be fully independent of the DIFC courts, and this is an important point to bear in mind. Despite the separation of powers and responsibilities, this new authority fulfills a dream that the DIFC authorities and my predecessor, former Chief Justice Sir Anthony Evans, had of making our courthouse a house of justice in its different forms. But the significance of this arrangement is that neither the DIFC courts nor the Arbitration Centre consider such cooperation to be against their own interests. Both institutions recognize that the imperative is to make DIFC the legal hub of the MENA region by offering a suite of legal options for dispute resolution and making sure that each option is satisfactorily delivered in accordance with parties' expectations. We in Dubai can take inspiration from London's example in maintaining a number of vibrant legal forms of dispute resolution, thereby enlarging the pool of disputes being resolved in our legal hub and interlinked to each other as necessary, for example, between arbitration and mediation. We are now about to launch in the DIFC an experiment without parallel in arbitration history. As I mentioned earlier, we have recently circulated for public consultation a draft practice direction setting out an initiative in the form of a guidance note that will have the effect of converting, within quotes, court judgments into arbitration awards. But as I will explain later, I use the term conversion as shorthand for a more complex process. But in brief, the protocol will be as follows. Now, at this point, could I ask that all of you open your handout and look at the revised version of the practice direction. So I will read very quickly, but you need to follow the wording because there are important points within it. Any enforcement dispute, as defined in DIFC Court's Practice Direction number number X of 2014, that satisfies all of the referral criteria set out in Practice Direction X of 2014, shall be referred to and be finally resolved by arbitration under the arbitration rules of the DIFC LCIA Arbitration Centre, which rules are deemed to be incorporated by reference into this clause. There shall be a single arbitrator to be appointed by the LCIA court pursuant to Article 5.4 of the DIFC LCIA arbitration rules. The seat or legal place of arbitration shall be the Dubai International Financial Centre. The language to be used in the arbitration shall be English. Now, the referral criteria referred to in this model clause are defined in the practice direction as follows. And if you look at your copy, I hope you have the copy which has the yellow highlighting. The yellow highlighting indicates where this current practice direction is different from the original one sent out for public consultation, and the changes are all due to suggestions made by the respondents. The first criteria is that the judgment has taken effect in accordance with Rule 36.30, which simply provides when a judgment takes effect either on the date of the judgment or a later date if the judge so orders. Second criteria is the judgment is not in respect of an employment contract or consumer contract, which is subject to Article 12.2 of the Arbitration Law 2008, precluding arbitration in respect of such contracts. One of the respondents did point this out, that under our arbitration law, there are some topics which are non-arbitrable. So obviously, we have to take that out. 3, 4, and 5 are in the same terms as they were originally drafted. The third criteria is simply that there's no appeal pending. Fourth criteria is that there is an enforcement dispute in relation to the judgment. I'll come back to the definition of enforcement dispute in a minute. And finally, the judgment creditor and judgment debtor have agreed in writing that any enforcement dispute between them shall be referred to arbitration pursuant to this practice direction. So you can only have an effective submission to arbitration if these 5 criteria are complied with. As I said before, the most important criterion of these 5 is enforcement dispute. And the definition of that is set out below. And if you look at the copy with the yellow shading, you will see again how this particular definition has changed between the first draft and now. The definition is this: a dispute between a judgment creditor and a judgment debtor with regard to any money, including interest and costs, due under an unsatisfied judgment. So you notice the changes there. We've added in interest for obvious reasons. Due under an unsatisfied judgment, to make it clear that what is going to be the subject of the arbitration is the unpaid amount of the judgment, if there's been partial payment. And it includes a failure to pay on demand any sum of money remaining due under a judgment on or after the date on which that sum becomes due under Rule 36.35. I apologize, Rule 36.34, and I won't bother you with the details of that rule for the moment. So that is in the same terms as before, except the word any. Again, just to emphasize, any sum of money remaining due under a judgment. The second example of an enforcement dispute is the ability or willingness of the judgment debtor to pay the outstanding portion of the judgment sum within the time demanded, but excluding any dispute about the formal validity or substantive merits of the judgment. So there are two points there. The first point is a dispute is not meant to be about whether or not the money that is the subject of the original dispute that led to the judgment is actually due as per the judgment. That is not what the dispute will be about. But it will really be about why the judgment debtor has not paid all of the sums due under that judgment. The second point that arises from this is to exclude any dispute about the formal validity or substantive merits of the judgment. So the judgment is supposed to remain intact and unimpeachable by the arbitral tribunal. Then we move on to the definition of judgment. Again, there's been some changes. A judgment includes a summary or default judgment. This was a suggestion by one of the respondents. And you'll see the last word in brackets, whether or not the judgment also provides for remedies other than the payment of money. Again, there was a respondent who mentioned what happens if you have a judgment which is partly for monetary relief and partly for non-monetary relief, for example, possession of premises upon the termination of a tenancy. So that covers those scenarios. Now, I've summarized the key elements in the protocol. The net effect of this initiative is, we hope, that following a money judgment of the DIFC courts, the judgment creditor will be able to demand payment of the judgment sum. And if payment is not made pursuant to that demand for any reason, the judgment creditor will be able to consider that an enforcement dispute has arisen and can refer the dispute to arbitration at the DIFC LCIA Arbitration Center or indeed any other arbitration center. But that latter course may not be the wisest course to be taken by the parties, but they would be entitled to choose another center if they wish, although this protocol may not work as well as it should if the arbitration is referred to our arbitration center. The arbitration center in turn will progress the arbitration, and the LCIA court will appoint one arbitrator as the parties will have chosen in their arbitration agreement, and you'll have a look at the model agreement in a moment. And the purpose of that is to ensure relative expedition in the progress of the arbitration. Then the dispute will be referred to the tribunal for its decision in the usual way in accordance with the arbitration rules of our arbitration center. This process is what I meant to explain by the term conversion of a judgment into an arbitration award. but it's not a conversion in the strict sense of the word. Our process enables a judgment creditor to have an additional option for enforcement of his judgment without losing its rights under the judgment in any way. So the judgment itself remains intact and fully enforceable without regard to the progress of the arbitration. The term convert is therefore simply a metaphor. Perhaps a more accurate, if less striking characterization of the process is to call it enhanced enforceability of the DIFC court's judgments. Less sexy though, right? Now, after our public consultation, we received a fair number of comments from several law firms within the DIFC. Their principal worries and my present thoughts on them are as follows. First, and this is the most important reservation shared by quite a number of firms, we were told that our definition of enforcement dispute will not work in creating a dispute on a judgment sum, which cannot be disputed, and whether a subsequent national court, which has to enforce the award, will consider that it was a mere rubber stamping of the judgment. Now, my reply is this. There is a long line of common law jurisprudence which clearly establishes that, for purposes of arbitration, a dispute exists when one party makes a claim for payment of a sum allegedly due from another party, and the respondent either refuses to pay or keeps silent, but in any event does not make payment. This is so even if the issue of whether or not the debt is owing is beyond dispute. Only a clear and unequivocal admission of liability or actual payment will mean that there is no dispute. In particular, there has been extensive English jurisprudence on the subject because of the legislative history of Section 4 of the English Arbitration Act 1950. Unfortunately, that has not been reproduced for you, but basically that is the section in the 1950 Act which says that if parties have an arbitration agreement and one of the parties then files an action in court in relation to that dispute, then the court must stay the court proceedings in favor of arbitration. But in the 1950 Act, there was a qualification that the court would not grant a stay unless satisfied that the arbitration or agreement has become inoperative or cannot proceed, or that there is not in fact any dispute between the parties with regard to the matter agreed to be referred. So those last words has engendered a lot of case law. There is not in fact any dispute between the parties with regard to the matter agreed to be referred. This provision was later repeated in Section 1 of the English Arbitration Act 1975, but was significantly modified by Section 9, subsection 4 of the English Arbitration Act 1996, which omitted the words that I've just read, unless satisfied that there is not in fact any dispute between the parties with regard to the matter agreed to be referred. 1996 was the critical date in English arbitration history. Both before and after 1996, a body of case law has developed to ascertain what a dispute means and its significance for future cases. Even after 1996, courts have referred to pre-1996 cases for guidance on the meaning and scope of the word whenever it appears in an arbitration agreement. In one of the earliest English cases on the subject, of Ellerin Brothers against Klinger, which was decided in 1992, Lord Justice Templeman held that there is a dispute until the defendant admits that the sum is due and payable. 8 years later, in 1990, his opinion was referred to in Hayter and Nelson Home Insurance Company by Justice Saville. Now, I don't know whether how many of you know this. Justice Saville later became Lord Saville of the Supreme Court, of the then House of Lords, and he was the person who was the primary draftsman of the 1996 Arbitration Act in England. So he's a person who knows something about arbitration. Now, Justice Saville in this case expressed the view that if the parties have agreed to arbitrate their disputes, the court should not ignore that bargain, merely because the parties are seeking a quicker remedy by pursuing the case in court. And Justice Saville gave the following example in his judgment to illustrate the point. Now, I'll read you this passage.